Hello, my name is David Winch. I'm a forensic accountant with Bartfield's Forensic Accountants. And in this session today, we are going to talk about confiscation, some of the fundamentals of confiscation. And because I do sometimes liken confiscation to the Alice in Wonderland world, we're going to talk about what Humpty Dumpty teaches us about confiscation. So let's have a look at the agenda. What Humpty Dumpty teaches us, and then into some fundamentals of confiscation, focusing next on the particular benefit, and we'll explain what that means, and then the benefit of general criminal conduct. Then what we mean by a criminal lifestyle, and what the statutory assumptions are in a case of criminal lifestyle. And finally, rounding up with how Bartfield's Forensic Accountants can help you. What did Humpty Dumpty say? When I use a word, Humpty Dumpty said in a rather scornful tone, it means just what I choose it to mean, neither more nor less. And that really does sum up the situation we have in confiscation, because we use in confiscation a lot of words and we use them in a special way, in a technical way, and they do not mean what they mean outside of the Crown Court, outside of confiscation proceedings. So let's think about unlearning the meaning of these everyday English words, because they do have special and somewhat unusual meanings in confiscation. And what words do I mean? Well, benefit, available amount, criminal lifestyle, and even the word confiscation. These words all mean something quite different in confiscation proceedings from what they mean in ordinary everyday life. So what are the fundamentals of confiscation? Well, the basics are very straightforward. When the court makes a confiscation order, it should concern itself with the benefit of the defendant's particular criminal conduct if he does not have a criminal lifestyle. And I'll explain to you what I mean by particular criminal conduct. And the benefit of the defendant's general criminal conduct if he does have a criminal lifestyle. And again, I'll explain what we mean by general criminal conduct. The confiscation order itself will normally specify the court's findings and decisions on various matters, including the defendant's benefit, the defendant's available amount, the amount which the defendant is required to pay, which is going to be the lower of his benefit and his available amount, the due date or dates for payments, and the default sentence to be served if payment is not made. And it ought to be the case that the defendant himself gets a copy of the confiscation order after the court hearing. It won't be immediately after, it'll be a day or two after. But I do come across quite a few cases where I say to defendants after their confiscation, can you show me the confiscation order? And they haven't received it. So if you're a lawyer acting for defendants, do please send them a copy of the actual confiscation order so that they know what it is that the court has decided. So particular benefit. Section 76 of the Proceeds of Crime Act 2002 refers to two categories of criminal conduct. And the first of these is particular criminal conduct. And a defendant's particular criminal conduct is the conduct concerned in the specific offences which form the grounds for the confiscation proceedings, and other offences of which the same defendant is convicted in the same proceedings, and other offences taken into consideration when sentencing the defendant for those offences. So those three items fall into a defendant's particular criminal conduct. The actual offences which have triggered the confiscation, any other offences for which the defendant is convicted in the same proceedings, and offences taken into consideration in sentencing in those proceedings. And so his particular benefit is the value of property, and the word property is used in this legislation to mean any type of asset. The value of property obtained solely or jointly by the defendant as a result of his particular criminal conduct or in connection with his particular criminal conduct. That's his particular benefit. It does also include a sum of money equal to the value of any pecuniary advantage obtained as a result of or in connection with that particular criminal conduct. So here we're talking about a liability that has been evaded, that has been sidestepped by that particular criminal conduct. So that arises particularly, of course, in tax cases where there's been an evasion of income tax or import duty or VAT or whatever. Then we're talking about a pecuniary advantage in that the defendant hasn't actually obtained cash in his hand, but he has obtained the value of evading the liability that he would otherwise have to satisfy. Okay, we've done particular criminal conduct. So then what is general criminal conduct? General criminal conduct is the conduct concerned in any and all criminal conduct in which the defendant has been engaged at any time. So since he was born, that is all his general criminal conduct. So obviously that will include his particular criminal conduct. The general criminal conduct is everything, all his criminal conduct. So what then is the benefit of his general criminal conduct? Well, it will include the benefit of the defendant's criminal conduct at any time, including benefit of conduct for which he has been convicted on previous occasions, on which he's previously been sentenced, as I say, since he was born, but where no confiscation order was made. It will include the benefit found in any previous confiscation order at any time against the same defendant, because again, we're looking globally here at his general criminal conduct, all his criminal conduct, and the benefit of all his criminal conduct. So if we've found benefit previously, then that's part of the benefit of his general criminal conduct. It will include assumed benefit, which now arises under the statutory assumptions of section 10. And we will have quite a lot more to say about the statutory assumptions in a few minutes' time. But when we calculate a defendant's benefit of his general criminal conduct today, we, in order to avoid double counting, we then have to deduct from that the amounts which he has been required to pay under previous confiscation orders. No, we're not deducting the amount of benefit found under previous confiscation orders. We're deducting the amount he's been required to pay under previous confiscation orders, which may be less, of course, than his benefit previously. So there could be residual benefit which he's not been required to pay from a previous confiscation order. That is going to fall into his benefit of general criminal conduct this time. And what's the bad news? Well, the bad news is that where the defendant has a criminal lifestyle, the court will also make certain statutory assumptions when ascertaining the defendant's benefit of his general criminal conduct. As I said, we will have a bit of a look at that in a couple of minutes' time. I've used the expression criminal lifestyle. So what is a criminal lifestyle? How does a defendant get a criminal lifestyle? First of all, as Humpty Dumpty would be proud to admit, it has nothing to do with the defendant's lifestyle. Absolutely nothing at all. It doesn't matter whether he drives a Bentley or a Fiat. He may have a criminal lifestyle, whether he is wealthy or penniless. It depends solely upon the defendant's convictions, so that we can ascertain, as a matter of pure fact, not a matter of opinion, pure fact, once we know the defendant's convictions in full, we can determine whether he has a criminal lifestyle, yes or no. And there are 4 alternative routes to a criminal lifestyle. They're set out in section 75, but we're going to go through them now. Route 1. Route 1 is the simplest one. The defendant has been convicted of at least one offence listed in Schedule 2 to the Proceeds of Crime Act 2002. And it doesn't matter, under this route, it doesn't matter if the defendant has obtained no benefit whatsoever from that offence. He can still have a criminal lifestyle. What are the Schedule 2 offences? Well, the obvious thing is to have a look in Schedule 2, but some of them we can briefly mention. Most drugs offences are in Schedule 2. One exception is that the cultivation of cannabis, contrary to Section 6 of the Misuse of Drugs Act 1971, is not a Schedule 2 offence. But the production of cannabis, contrary to Section 4 of that Misuse of Drugs Act 1971, is a Schedule 2 offence, and perhaps for that reason you will usually find cultivation will be charged as production under Section 4 rather than cultivation under Section 6. But generally the drug trafficking offences, they're all in there in Schedule 2. Money laundering offences as well are in Schedule 2. The money laundering offences under Sections 327 and 328. They talk about transferring criminal property, concealing criminal property, removing criminal property from the jurisdiction of England and Wales, entering an arrangement with another regarding criminal property. Those are Schedule 2 offences. The Section 329 money laundering offence, possession or use of criminal property, is not a Schedule 2 offence. Perhaps surprisingly, well, it surprises me anyway, some trademark and copyright and counterfeiting offences are in Schedule 2. So if you've got a chap at a car boot sale selling fake Nike trainers or something like that, then he's committing a Schedule 2 offence. He has a criminal lifestyle, even if he doesn't obtain any benefit. And there are various other offences which are listed in Schedule 2. Finally, there's a sort of roundup: conspiracy and attempt and so on in relation to a Schedule 2 offence. That itself is a Schedule 2 offence. So if you have, let's say, an attempt to import into this country some drugs, and it doesn't actually happen, the import never happens, doesn't matter if the defendant is convicted of the attempt, then he has a criminal lifestyle because that attempt is a Schedule 2 offence. So that's route 1, that's the simple one. Route 2, a defendant has been convicted of at least one offence committed over a period of at least 6 months, from which he has obtained a benefit of at least £5,000. So a single offence here, committed over a period of at least 6 months, with a benefit of at least £5,000, causes this defendant to have a criminal lifestyle. So, for example, a social security benefit fraud offence, which continues over a period of at least 6 months and results in a benefit of at least £5,000, bang, criminal lifestyle. A tax evasion offence, which continues over a period of at least 6 months and results in tax evasion of at least £5,000, bang, criminal lifestyle. An employee abusing his position to defraud his employer, for example, over a period of at least 6 months and obtaining a benefit of at least £5,000, again, criminal lifestyle. Route 3 is a little bit more complicated. The defendant has been convicted in the same proceedings of at least 4 offences, from each of which he has obtained some benefit. And the aggregate benefit of which he has obtained from these offences is at least £5,000. So, for example, if I am a shoplifter, on 3 occasions I shoplift a bar of chocolate worth £1, and on a 4th occasion I shoplift something worth £5,000, then I will have been convicted in those same proceedings. If I'm dealt with in the same proceedings with all those shoplifting offences, I will have been convicted of at least 4 offences, from each of which I obtained a benefit. Even though the first 3 I only obtained a very minor benefit, I obtained a benefit, and the aggregate benefit from the 4 of them is at least £5,000. So yeah, I've got a criminal lifestyle. Another example, a defendant is convicted in the same proceedings of offences of fraudulently transferring to his own bank account on various dates monies held in the account of a vulnerable person for whom he held a power of attorney. Let's say the amounts transferred in respect of the offences were 250, 300, 2,000 and 2,500. Then the total of those is at least £5,000, it's 5,050. He's convicted of 4 offences of which he's obtained a benefit, criminal lifestyle. Route 4 is probably the most complicated of them all. And here is where a defendant has now been convicted of 1 or more offences and has also been convicted on at least 2 previous occasions within the past 6 years of offences, from each of which he has obtained some benefit. And the aggregate benefit which he's obtained from all these offences is at least £5,000. So let's think of an example. A defendant was convicted of a theft of £1,000 in 2016. He was convicted of another theft of £3,000 in 2019. And he's currently being sentenced in 2021, having been convicted of a theft of £1,500. So the total benefit of these offences is at least £5,000, it's 5,500. And he has been convicted on this occasion of an offence from which he's obtained a benefit, and also been convicted on 2 previous occasions of offences from which he's obtained a benefit. So he has a criminal lifestyle. That's not one, I have to say, I come across very often, but that is the 4th route. Aside from these 4 routes, there is no way that a defendant has a criminal lifestyle. If he doesn't satisfy the conditions of one of these 4 routes, then he does not have a criminal lifestyle. It's kind of black and white. What about offences taken into consideration in sentencing? Well, there's a bit of a trap there for defendants, because where other criminal conduct is taken into consideration on sentencing, any benefit from that conduct as well counts towards satisfying the £5,000 of benefit required to have a criminal lifestyle under routes 2, 3 and 4. So TICs are not terribly helpful to defendants from that point of view. We said that if you have a criminal lifestyle, then the statutory assumptions apply. How do they work? Well, let's assume that we're dealing with a defendant who has never previously been subject to confiscation proceedings in which the statutory assumptions have been available to the court. I make that assumption because if he has, then various complications arise, and I don't really want to go into all those complications today. There are 4 statutory assumptions in section 10, and it's easier for me not to take them in the order in which they appear in the section. All of the assumptions are subject to an overriding caveat, which we will mention towards the end. So, take this one first. It is assumed for the purpose of valuing any property, and property, as we've said, means any asset, that the defendant obtained it free of any other interests in it. So when we're valuing it, we just assume, our starting position is that we assume that the defendant has the sole interest in it. Next assumption. It's assumed that any property held by the defendant at any time after the date of his conviction was obtained by him as a result of his general criminal conduct and at the earliest time he appears to have held it. So let's assume I'm convicted of an offence and I have a criminal lifestyle. There's a property I own which I purchased in 1979. That, because I still own it, if I still own it after the date of my conviction, that is going to be assumed to have been obtained by me as a result of my general criminal conduct. And obviously, when we talk about benefit and confiscation orders, that then is going to fall into the benefit figure, unless for some reason I can get it taken out. Next assumption. It's assumed, and this is in a sense the big assumption in most cases, it's assumed that any property transferred to the defendant at any time after the relevant day was obtained by him as a result of his general criminal conduct and at the earliest time he appears to have held it. So here we're talking about, for example, credits to a defendant's bank account. It's going to be assumed, or can be assumed, that all credits to the defendant's bank account after the relevant day, and we'll explain what we mean by the relevant day, after the relevant day were obtained by him as a result of his general criminal conduct. Next assumption. It's assumed that any expenditure incurred by the defendant at any time after the relevant day was met by property obtained by him as a result of his general criminal conduct. So what we're saying here is, again, suppose that I'm the defendant who's been convicted and I have a criminal lifestyle, then where I have, let's say, purchased a new car, after the relevant day, it's assumed that the money I used to purchase that car was obtained as a result of my general criminal conduct, unless we can counter that, as we will come to in a minute. The relevant day. What do we mean by the relevant day? Well, we're talking, as I said here, about somebody who's not been subject to confiscation previously, where the criminal lifestyle assumptions could have been applied. Because that would bring in complications. So that being the case, the relevant day is going to be the first day of the period of 6 years, which ends on the day on which proceedings for the offence concerned were commenced. And the offence concerned means the offence which forms the basis of the confiscation proceedings. And when are those proceedings commenced? Well, typically they are commenced on the date in which the defendant was charged with the offence of which he was ultimately convicted. So we'll give an example of that later on. Okay, George. Here's the example. George is charged, let's say he's charged on the 19th of May 2021. With an offence under Section 4 of the Misuse of Drugs Act, which is supply of a controlled drug. With our crystal ball, we know that he's going to be ultimately convicted of this offence on the 17th of November 2022. The relevant day is the first day of the period of 6 years, which ends on the day George is charged. So George is charged on the 19th of May 2021, period of 6 years, which ends with that day, starts on the 20th of May 2015. So that's the relevant day in George's case, 20th of May 2015. That means that two of the statutory assumptions will apply to the period after 20th of May 2015, so starting on 21st of May 2015. And the further assumption applies to property held by him after the date of conviction. We know the date of conviction is 17th of May 2022, so the further assumption will apply to property held by him at any time after 17th of May 2022. George is going to be made subject to a confiscation order at a hearing on the 3rd of July 2024. So two of the statutory assumptions apply to the period after 20th of May 2015, so starting on the 21st of May 2015, and up to the day of the confiscation order, which is the 3rd of July 2024. So in practice, they're going to apply for a period of about 9 years. We often talk about these statutory assumptions applying for a 6-year period, and actually that's not right, is it? They're actually applying for a longer period. The 6 years is the 6-year period that we use for calculating the relevant day. But the assumptions will run up to the day of the confiscation hearing. So the assumption relating to property held by him after the date of conviction applies to any property held by him at any time after 17th of November 2022, when he was convicted, and up to 3rd of July 2024. Any property held even for 1 day in that period, the assumption can apply to. I mentioned overriding caveats, and let's get them sorted now. The overriding caveats are that the court must not make a required assumption in relation to a particular item of property or expenditure if, on a balance of probabilities, because in confiscation we're always talking about the balance of probabilities, not about beyond reasonable doubt or being sure. On a balance of probabilities, the assumption is shown to be incorrect, or there would be a serious risk of injustice if the assumption were made. Note that the wording is a serious risk of injustice, not a risk of serious injustice. Any injustice, of course, might be regarded as serious. One thing for prosecutors to remember, and they don't always, is that the initial burden is on the prosecution to show, when they're using the assumptions, the burden is initially on the prosecution to show, for example, that property has been transferred to the defendant, or that expenditure has been incurred by the defendant after the relevant day. For example, they can satisfy that burden by producing bank statements which show credits to a bank account held solely or jointly in the name of the defendant. That will satisfy that initial burden on the prosecution to show that the property has been transferred to the defendant after the relevant day. Or a paid invoice for the purchase of a motor vehicle by the defendant will show that expenditure has been incurred by the defendant after the relevant day. The case law on that, if you ever need to quote it, is the case of Whittington, and the reference is there on the slide. Once the prosecution has satisfied that initial burden on them, which, as you will realise, is not a difficult burden to satisfy, once the prosecution has satisfied that initial burden, then the burden shifts to the defendant to satisfy the court, again, on a balance of probabilities, for that, for example, the monies or the property are derived from a legitimate source. And if you do that, then you have shown that the assumption that they are derived from his general criminal conduct is incorrect. And that's what we spoke about, didn't we? The assumption being shown to be incorrect. Or that, for example, there would be a duplication inherent in the prosecution assertions. And if there is, then you're showing a serious risk of injustice. So let's take the example of buying a car. If I have bought a car for £10,000, if I have paid for it in cash and there is no known source of that cash, then the prosecutor is going to be successful, isn't he, in his assumption that that expenditure has been funded for my general criminal conduct, because I have no other explanation. If, on the other hand, I can show that actually the £10,000 was paid out of a bank account, and the bank account, my bank account, has already been taken fully into account in terms of the deposits to it have been assumed as benefit and so on, then to assume that the expenditure of that money, which is already assumed to have been benefit, is further benefit, is a duplication. And that would involve a serious risk of injustice. And so where the expenditure to buy the car has come from a known source, whether it be a known illegitimate source or a known legitimate source, then assuming that that is benefit will be incorrect, because it either involves a duplication or it involves monies which we've demonstrated to be legitimate. So those are a couple of examples of where the statutory assumptions are rebutted by defence evidence. Of course, a forensic accountant's report can be particularly helpful in presenting information to the court which may assist. And one of the things, of course, which the forensic accountant can do, which the instructing solicitor cannot do, is actually go in the witness box, if need be, at a confiscation hearing and say, these are the documents, this is what I've looked at, this is what I found. And can deal with the assertions put forward excuse me, by the FI for the prosecution. The forensic accountant can examine records of past transactions and ownership of assets and search out duplications and other errors in the prosecution's asserted benefit computations. Excuse me. So how can we help? Well, Bartfield's Forensic Accountants remains fully staffed, undertaking legally aided and privately funded criminal and civil forensic accountancy work. We have been very fortunate during the pandemic in that it's been possible for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities. We remain, of course, readily contactable by phone, by email, and online, Zoom meetings, Teams meetings, and so on. Probably the easiest thing to do if you have got an inquiry is to email us and send us relevant documents so that we can look at them, consider them, and give you a full and proper reply. Our recently updated website is full of useful information, and of course that is accessible 24/7. You can find more on this topic in our website blog articles, and this and our previous webinars can be found in the seminars section of our website. We will send you a free recording of this webinar. We'll email that to you. And if you have questions, do please contact me. My email address is there. As I say, the email rather than the phone is the better way to deal with these sort of complex issues. Thank you very much for your time, and I will see you again in a fortnight. Thank you.